I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. Today I'm going to offer some observations on judges and judging. For the most part, bankruptcy judges are pretty good at making the right decisions. We may disagree, but they get it. Bankruptcy judges devote their lives to bankruptcy law, boring as it is, but as a consequence, they understand the consequences of their decisions. But sometimes that's not true when a case goes up on appeal, because from bankruptcy courts, you go first to U.S. district courts and then to the U.S. Court of Appeals in your area. Those judges at district and circuit courts are called Article III judges. And for most of them, if not practically all of them, they very seldom get bankruptcy issues. And so it's really not fair to expect that they will understand all of the ramifications of what they say. And that's what happened just this week in a decision by the U.S. Court of Appeals for the Second Circuit. They handed down a decision on a very narrow issue, but the holding they made was very, very broad. And I suspect they may not have understood the ramifications entirely of their decision. As background, about 2 years ago, the Supreme Court handed down a case called Taggart versus Lorenzen. And that decision told us that you have to jump through a lot of hoops to get a finding of contempt against a creditor for violating the discharge injunction. Well, immediately the question in everyone's mind was this: does that very high standard in Taggart also apply elsewhere in bankruptcy, and particularly with respect to alleged contempt for violation of the automatic stay? Well, in this decision from the Second Circuit to which I refer, the court had a very broad holding, which appears to say that that difficult high Taggart standard applies to all contempt situations in bankruptcy court, which would include, of course, contempt of the automatic stay, which is the backbone, the foundation of what bankruptcy law is all about. The case actually involved a very narrow point about bankruptcy rule 3002.1, but as I said, the Court of Appeals went far beyond it. And in addition, even on that narrow issue involving Rule 3002.1, the court said that you can never get contempt or punitive citations against a creditor for violating that very important rule. And I think perhaps they didn't understand that because you cannot get contempt citations, the rule becomes virtually worthless, because all a creditor can recover is economic damages, which are going to be minimal. And I'm not sure whether lawyers are going to be willing to take on a case where there's virtually nothing that can be recovered in terms of damages. I do want to say, however, that there most likely will be a petition for rehearing en banc in the Second Circuit from this decision early this week. That means that if granted, all of the active judges on the Second Circuit will sit together and decide whether that decision is correct or not. And I suspect if they do hold rehearing en banc, there will be scads of amicus briefs filed by professors and others trying to tell the Second Circuit judges the ramifications that they may have missed when they handed down their decision this week. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. As usual, I will return same time next week with something interesting in the world of bankruptcy. Until then, be well, stay safe, good day.